Hello Oliver, thank you very much for that useful video, and I'm sure a lot of immigrants who will watch this video will be able to take some useful information out of it and plan their journey towards regularizing their stay in the UK. Now we're going to ask you some questions that some of the clients have asked us, and hopefully the answers will be useful to them and they will be able to act upon them. So a gentleman has asked, our child is born in the UK and is now 7 years old. Can we apply for his stay in the UK? Also, does it regularize their stay too?
You mean the parents' stay?
That's correct, yes.
Well, I can't give a simple answer to this question because there isn't one. But talking in a proper legal way, the child can apply to regularise their situation in the UK under the 7-year private life rule. However, my experience is that if the child does make such an application, the Home Office are likely to write to the child or to their lawyer asking what the intentions of the parents are. This means perhaps that the parents might be encouraged to make applications themselves, and then whatever happens with the decision making. But to answer your core question, if the child gets their status regularised, it does not mean that the parents will get their status regularised as well. First of all, because it doesn't work that way. Secondly, because the parents won't get their status regularised until they've made a successful application for that. No one gets regularised status without having made an application in the first place.
Brilliant. A lady has asked, saying her daughter is not born in the UK but has now lived in the UK for 7 years. She wants to find out, can her daughter apply to regularise her stay?
Is the daughter under 18 still?
That's correct, yes.
I can give a clear answer to this. Yes, she can. The rule says that you have to have lived in the UK for 7 continuous years. The rule under the 7-year rule does not say that the child has to be born in the UK.
Brilliant, that's great. And parents have asked, our 2 children have lived in the UK for 10 years. Can we apply for their British registration? And if we do, can we apply for our British citizenship at the same time?
First question I'd like to ask you, were the children born in the UK?
That's correct.
In that case then, if they meet all the other requirements, they can indeed apply for registration as British citizens. I can't see any strong reason for the parents to apply for British citizenship at that point because they won't qualify for it. As I was explaining earlier, when the child makes such an application for registration as a British citizenship, the registration is just about the child. It's not about anybody else.
Okay, great. Moving on to our next question. A lady has mentioned that she came to the UK as a Tier 2 dependent, and a child was born in the UK, and the child is now 7-year-old. The father of the child and the mother have separated, and they're no longer in relationship, and the lady is basically overstaying her Tier 2 dependent visa. She would like to find out, based on the information, that her father of the child has now acquired British citizenship and is happy to support any application for the child to remain in the UK. Can she make an application for the child to either become British or stay in the UK?
Yes, if the father will cooperate, the child could make a probably strong application for registration as a British citizen. It's as simple as that. The child wouldn't have to bother to apply for a visa or leave. The child is entitled to British citizenship because the father is now a British citizen.
That's very good news for the family.
Indeed.
Great. And our next question is, our child is born in the UK and is considered stateless as per the letter from the Indian Embassy. Can our child apply for his stay in the UK? Also, can we apply for any status based on this child? The child is 7 years old.
All right. This is a slightly different area of law. as far as I know, it may only apply to an Indian family. It might apply to other nationalities, but certainly it applies to an Indian family. This is something that was established in case law a few years ago. If a child is born of Indian parents in the UK and is deemed to be stateless, for example by the Indian High Commission, has lived in the UK for 5 years, has never travelled abroad, never left the UK, and the child is not entitled to any other nationality, then the child is entitled to register as a British citizen under another different part of the British Nationality Act 1981. But that doesn't help the parents. Again, this is an application made by the child. The parents are not in this picture.
Okay, so that means parents will need to submit a separate application to regularize their stay, perhaps on the basis of a British child.
Yes, they'd have to make some sort of application, maybe perhaps outside the rules based on Article 8, something like that. But that would come afterwards. First, the child would have to get their British citizenship.
Another question is, I am a single parent and have overstayed my visitor visa. I'm in the UK for 6 years and my child who was born in the UK is now 5-year-old. Can I apply for my child to remain in the UK?
Anybody can apply for anything, but I would have to give you honest advice about this. There isn't any strong application that could be made at the moment. If you'd asked me a different question, if you said that the child had been here for 7 years, then the child could make an application. Whether strong or not, it rather depends. But as the child has only lived here for 5 years, at the moment the child could not make a strong application.
Brilliant. Thank you so much for answering all these questions. And we will wrap this vlog for today. And we see you in the next vlog. Thank you.
Yes, indeed. Thank you very much.
Take care. Bye-bye.
Bye-bye.